Hi, I'm Kate Sellers. I'm here to talk to you today about whether COVID-19 will impact your employment practices liability insurance, which is also called EPLI. As you might suspect, as with everything else in our world, the answer is yes, the pandemic will affect your EPLI insurance. Here's the agenda that we're going to cover today. I wanted to start out just by introducing myself briefly. Again, my name is Kate Sellers. I'm one of the owners of Charles Sellers Insurance Agency. We're celebrating our 100th year this year in business, which we're very proud of. And we're also very proud of the fact that our business is focused on serving physicians and physicians' practices. Um, we work with hundreds of medical practices, including many orthopedic practices across New York State. I have been working at the agency for about 11 years. Prior to joining my family business, I practiced law for about 12 years, and one of the main areas of practice I worked in was defending employers against employment litigation claims. So this is an area very near and dear to my heart. So the other items we're going to discuss today are just a brief overview of employment practices liability insurance, some of the claims that we're expecting to see and starting to see under EPLI insurance policies related to COVID. We're going to discuss some exclusions found in most EPLI policies that will be important as these COVID-related claims come up. We're going to talk about COVID's impact on EPLI policies for those who have coverage now and for those looking for new coverage and first-time coverage. And then I have a few best practice type recommendations to make for you. So just as an overview as to what EPLI is, employment practices liability insurance, it protects a business from claims that can be made by employees, such as discrimination or harassment, and that can be on the basis of any number of protected classes under the law, such as sex, race, disability, age, religion. And there are many flavors of discrimination claims. It can be that the employer failed to hire or promote for a discriminatory reason, terminated someone for a discriminatory reason, set conditions of employment that were discriminatory, for example, setting hours or locations for work based upon a discriminatory reason. Some people are surprised to hear that you could be sued for failing to hire somebody. So you could be sued by somebody in an employment claim when they're not actually your employee yet. But we have seen medical practices sued under those circumstances where they have not hired somebody who interviewed for a position and they've been sued in connection with that. So that's important to know. One of the most important areas of employment practices litigation is retaliation. Those are claims that an employee can make saying that that actions were taken against them that hurt them for retaliatory reasons. They were being retaliated against for exercising rights, such as complaining about discrimination or harassment. And those are important claims to have covered under EPLI because they're very frequently made. And then EPLI policies can also protect against claims made by employees that their privacy rights have been infringed upon. A little bit more on the basics of EPLI. Other claims that may be covered would include wage and hour claims made by employees. Those would be claims that someone should have been paid overtime or was not paid for hours worked. Some policies provide that coverage and some don't. An EPLI policy may provide third-party coverage. That is coverage for claims made by individuals who are actually not your employees. This could be your patients, people who bring your patients in for appointments, a drug rep, anyone who comes in your office who's not an employee who may be able to sue you for discrimination or harassment. That's especially important coverage to have in New York State, where recent legislation made clear that business owners can be liable for discrimination or harassment of non-employees. Not every EPL policy provides third-party coverage, but that's something you want to confirm that you have. An EPLI policy provides both defense and indemnity, like other liability policies typically do. So the defense covers your defense costs, which primarily are attorney's fees, which can be the lion's share of the costs associated with this type of claim. And then indemnity, that indemnifies you for a settlement or a judgment if you go to trial and lose. And those damages in employment cases are a little unique in that they can include lost wages, but also punitive damages. And the employment statutes also provide for the payment of attorney's fees by the losing party, the prevailing party's attorney's fees. So the damages can be quite extensive, making this insurance particularly important. It's really important too to recognize that this type of coverage is not typically included in other policies you may have. Sometimes business owners think that their general liability policy or their business owner's policy includes this coverage, and sometimes it does, but it often does not. So it's important to know if you have this protection or not. I wanted to talk just a little bit about some special considerations that apply for employment practices liability insurance when the insured is a medical practice. We write employment practices liability insurance for a number of medical practices, and the insurers have special considerations when they're determining what coverage to offer and at what premium and other terms. One situation that drives how EPLI is underwritten in a medical practice is that in the typical medical practice, and I would say this is certainly true of the orthopedic practices we work with, for the most part, the owner physicians are primarily males, and the staff is very heavily weighted towards females. So that type of power distribution certainly creates a ripe field for employment-related claims, real or imagined. So that's an important factor. It's the same thing with law firms and some other types of businesses, but medical practices in particular have that power dynamic in play, which can be a concern to an EPLI insurer. Also, the damages in an employment suit with a medical practice can potentially be very high when compared to other businesses if the group includes non-owner employed physicians. Since a component of any potential damages is lost wages, and an employed physician is generally a much higher compensated employee than the typical employee, that potential for higher damages can be of concern to insurers, leading to things like higher deductibles in some situations. And then finally, another aspect of writing EPLI for medical practices is the fact that in a medical practice you have more potential of abuse and molestation claims by third parties. And insurers are, of course, aware of that potential. Typically, those types of claims are excluded from coverage. We do have some carriers who will write some limited coverage for those types of claims, typically just the defense coverage, but that's another factor at play when you're looking at EPLI for a medical practice. So the EPLI market was getting a little tougher before COVID-19. The Me Too movement was something that was impacting this market. And of course, now with the pandemic, there are more possible EPLI claims than ever. I know as a business owner in the spring, I never felt like I had to make as many decisions in my life as I did over that span of months. And I'm sure that's true for any business owner listening to this presentation. It was truly exhausting, and many of those decisions were employment related. And when you're making lots of hard decisions as an employer, that's when you're opening yourself up to the possibility that those decisions are going to make some employees unhappy, and an unhappy employee may sue you. So some of the potential claims that may come out of the pandemic would include things like a furloughed worker who may claim that they were chosen for furlough because of their gender, age, race, things that are illegal discriminatory reasons for making employment decisions. There was lots of change with leave laws during the course of the pandemic, in particular, the Federal Families First Act. So employees may claim that employers failed to provide them leave as they were required to do under the law. That type of claim is probably not covered by most employment practices policies, but if the employee could turn that into a retaliation claim, for example, say that they were demoted because they asked for leave under the Families First Act, that could be a covered claim. There could be other similar types of retaliation claims that would be covered by employment practices policies. For example, someone could say they were terminated because they complained about lack of safety requirements or put on a shift they didn't like because they used COVID-related leave, things of that nature. You could also have employees with disabilities who could claim that their employer's return to work policies discriminated against them. I know that's an area many employers have really grappled with, how and when to bring people who were home back into the office, and then dealing with their particular health situations. That can certainly give rise to employment claims. There's definitely a concern that we're going to see a lot more wage and hour claims, employees claiming that they should have been paid overtime or that they weren't paid for all their time worked, because it's harder to track people's work hours if they're working remotely or working flexible shifts or different shifts than they normally work. And with all of the upheaval we had over the last 6 or 7 months, those types of claims are really expected to spike. And then we're also expecting we may see some more employee privacy claims. These could arise if you had an employee who had COVID and you were trying to contact trace within your office, especially in a smaller office, or even a medium-sized office. It could be very difficult to trace people without disclosing an individual's COVID status. The next topic I wanted to cover are some exclusions that are found in most employment practices policies that are going to be important when we look at the claims that we're expecting to come in as a result of the pandemic. EPLI policies are not particularly standardized policies compared to a lot of types of coverage that are out there, but they do, for the most part, have very similar items excluded from coverage. I know nobody really likes the topic of exclusions from insurance coverage, and people get upset when they think about insurance coverage exclusions, but it's the way that an insurance company can provide coverage while excluding things that are too risky or not meant to be covered by this policy, meant to be covered by another policy. So some exclusions that we're likely to see come into play would be that almost every employment practices policy has a bodily injury exclusion. So if someone says, I'm suing you because you made me come back to work and I got COVID at work. There are a lot of issues with that type of claim. Primarily causation is going to be hard to prove, but those claims will not be covered by employment practices policy. Those are probably more in the workers' compensation realm. Similarly, employment practices policies exclude workplace safety claims under OSHA. They exclude claims of leave requests relating to leave requests under the Family Medical Leave Act, FMLA. As I discussed previously, when it comes to wage and hour claims, which are really a hotbed of litigation, those are covered by some policies, not by others. The policies that do cover them greatly vary as to the extent that they cover those claims. And then employment practices policies also tend to exclude claims under the WARN Act. That is an act that applies to larger employers, 100 employees or more, who are going to do a significant layoff um, or downsizing of their workforce, and there are requirements as to notice that must be given. So if there were violations of the WARN Act during the pandemic and claims are made against the employer, those are not covered by most employment practices policies. An EPLI policy will cover a lot of claims that we're going to see arising under COVID, however. So um, I wanted to go over what you're going to see as far as COVID's impact on the EPLI market. And I put the little skip 2020 picture on here because it's not terrific news, and like a lot of other things happening now, makes you wish you could skip ahead. We're in what's called a hard market, meaning it's more difficult to find policies. There are fewer options, and those options might not be as favorable as they were in the past. But there are still policies available. We're still encouraging people to look for coverage if you don't have it. And if your practice already has EPLI in place, we would just warn you that the renewal process might be a little bit more cumbersome. You know, your policy has an annual term, and at the end of that annual term, um, you look to renew it for the next policy year. Sometimes that process can be quite easy. You might not just need to answer a few questions for the insurer to get your renewal terms. We're finding that that process has become a little bit more cumbersome, where the insurers want more information. Some insurers are requiring their customers to complete COVID questionnaires when they renew their policy. They'd like to check up on how you're handling employment-related issues in light of COVID. The terms that you're offered on renewal may be a little bit less favorable. You might be seeing higher premiums and higher deductibles. And we know that a higher premium is hard to face right now in the current economic climate. Some insurers are also starting to add express COVID or pandemic or communicable disease exclusions to their policies, but we would still say don't let that policy go. Absolutely, if you have an EPLI policy in your practice, hang on to it. Because if you apply for new coverage, chances are you will not get terms as favorable. You may not get offered coverage by the same insurer. So we know that revenues are down, and it's tempting to look at insurance coverage that you don't have to have. It's not required by anybody. It's tempting to let those policies go, but we would absolutely advise against letting any EPLI policy go. Employers are more likely to get sued now than probably at any time in recent memory. And this is not the time you want to go without coverage, and it can be hard to get it back, especially on the same terms that you have it now. If your practice doesn't already have EPLI, I still would very strongly encourage you to apply for it. It's more important than ever to obtain it. There may be fewer options available. A carrier that we use for a lot of medical practices is not offering new policies at this time, but we do have other options. And the terms may be a little less favorable, but if you get sued by an unhappy employee or an unhappy former employee, it will mean the world to your financial protection to have one of these policies in place, to get your defense costs covered by a good employment defense lawyer, and then to have that indemnity there in case you have to pay a settlement, or heaven forbid, a judgment. So a couple of recommendations that I wanted to end on. One is right now it's really important to be extra careful in tracking the hours your employees are working, especially this is especially important with telework, flexible scheduling. You want to make sure that you're tracking those hours, and where overtime is required to be paid, that you're paying it. If you have any kind of automation that can keep track of those hours, that's all the better. But that's just something you want to be really vigilant about to prevent those wage and hour type claims that can be so hard to defend against. If you have an employment practices liability policy in your practice, most of them include some services to help you prevent a claim at no charge or at a reduced cost, for example, consultations with an employment attorney, we really urge you to use those. Have your office manager look into them and see what's out there as far as resources. Certainly, if you're thinking about terminating an employee, reach out to that employment attorney or one that you trust to walk through it and make sure it's a good decision and that you have the right documentation in place and that you're not going to regret that decision later. If you do have an EPLI policy, we would really encourage you to pull it out and review it, or have your office manager meet with your agent or broker and review it so that you know just how much coverage you have. If you haven't had to use it, which hopefully you haven't, you may have forgotten, but it's a really good time to find out what gaps you may have now when you can do something about it rather than after you've been sued. This is a little bit off topic, but it's along the same lines, just a reminder that the New York paid sick leave law went into effect in September, and employees can start using paid sick leave as of January 1st. So that's something you want to make sure your policies are updated on to avoid future problems and the need to use your employment practices insurance or other insurance. So that's certainly something to look into if you haven't yet, or to ask your office manager to. And then one last final word is, if you do have coverage and an employee is sending complaints about an employment decision that's been made in respect to them, remember to contact your carrier quickly to put them on notice of a potential claim. You, again, contact your agent or broker, talk through it with them, and get that carrier put on notice of a potential claim so that you don't jeopardize your coverage. Thank you so much for joining me today. I hope this was helpful to you. If you have any questions about employment practices liability insurance or any of the other insurance that you have for your office, please feel free to reach out to us at Sellers Insurance. My email address is there and phone number, and we would be happy to help you. Thank you.